Hi, you are watching SightsIn Plus, and this is Romesh Shivasto. Please do subscribe the channel for the HR news, for HR updates, and conversation with the top-notch CHROs. Today, we are going to discuss about the sexual harassment at the workplace. Earlier, we have also covered this topic, and we have discussed that what is the sexual harassment, even when the people are working remotely, how to form, how to constitute the ICC, and what is the role of ICC, how to file the complaint, etc. In another video, we have also covered that how to file the annual return under the POSH Act. Today, we are going to understand a Supreme Court's recent judgment. And in this judgment, the Supreme Court of India has flagged certain serious lapses and uncertainties under the POSH Act. And the Supreme Court of India has also issued certain directions to strengthen the POSH Act at the workplace. To understand this better and to discuss in detail, we have two senior POSH experts. Let me introduce Mr. Jayant Bakshi. He is a lawyer, founder, and practice leader at SolvingComplexities. Another senior POSH expert is Ms. Mona Singh. Mona is a coach and POSH trainer at Yara Coaching. So, Jayant, if I come to you first. So, according to the Supreme Court's order, what are these serious lapses and uncertainties for implementing the POSH Act?
Thank you, Ramesh, for having me. Let me actually begin by talking a little bit about the judgment that you refer to here. This is actually a case law. It's called Aureliano Fernandez versus State of Goa. This is a 61-pager judgment by the Supreme Court of India. And while the first part of the major part of the case is about two individuals, POSH matter, at the end of the judgment, there's an epilogue. Now, epilogue, as you typically know, is conclusions, comments at the end of what has happened. In this epilogue, the honorable judges are saying that while we're celebrating that the POSH Act has been there for 10 years, it's legislated now. It came around 2013. So they say, while it's been 10 years, let's also look at the fact that how well have we done as far as the implementation is concerned. And now they're concentrating only on 2 points as far as the implementation is concerned. The first one is proper constitution of IC, internal committee, local committee. And the second is training of ICs and internal committees, local committees. So these are two things they have concentrated on. Firstly, they are saying that, if you do not make a proper, IC, if you do not constitute an LC properly, it would be an impediment in conducting an inquiry. Secondly, they are talking about training. They're saying if it's a ill-prepared committee, the committee members do not know how to do an investigation, they will only conduct a half-baked inquiry, which will lead to serious consequences. Now, these are a few things that they have picked up. Now, you would be wondering why in a private matter, suddenly the government has come out and given directions. And directions have come out to everyone. This is something actually which is happening today on the roads. You would see, in the light of what has happened in the backdrop of the restless protest in Delhi, with the, you may have heard of this. So with this as a background, when the judgment was being delivered, the honorable judges said that, we looked at a national daily newspaper, and this newspaper seems to have conducted some kind of a survey. The survey said that out of 30 sports federation in the country, only 16 had ICs. In fact, I'll correct myself. 16 did not have ICs till date. That's the right survey. So almost 50% did not have ICs. Then the government went ahead and, in fact, the judges went ahead and even said that even when there are ICs, the stipulated number of members are not present. For example, every IC must have an external member. That member is not present. Even if they are present, they are not very well educated on how to carry out an investigation. All of these things are lapses which the government is talking about here. So these are the serious lapses which are being spoken. Let me pause here and for Mona to please also add.
Sure, Jan, sure. Mona, what are your views on this Supreme Court judgment when we talk about the serious lapses part?
Yeah, hi Ramesh, thank you for inviting me. Hi Jayant. Yes, Jayant has already, highlighted what are the lapses which have been identified in the recent cases. Even the sports federation case which is going on, there also the same thing has been highlighted. The main issue is that these things are not taken care of. The IC committee meeting is not there, and people do not know how to approach for the redressal under this act, and also they lack confidence in the whole process. They do not believe that if even if they come forward for the redressal of their the behavior that they have been subjected to, it will be resolved or it will be addressed to. So they get scared of that, and it not only affects person's self-esteem, it also affects their mental and their physical health, undergoing such kind of trauma that they are going through. So yeah, the time has come that these things are addressed, and timely these things are becoming highlighted, that the IC committee is made properly with full members and the external members, and also the how to address the such kind of incidents which come in the highlight.
Right. So, Jayant, I think the Supreme Court has also stressed on time-bound verification. And if you look at the Act, so certain timelines are already fixed there for the redressal. So maybe some activities in 7 days, then 30 days, then 60 days or so. So how do you see this observation of the Supreme Court?
The 30-day or a 60-day is actually the amount of time mentioned in the law to carry out certain processes. The time-bound exercise has nothing to do with that. It's a very different concept. So what has happened now is the government in the first part, as I mentioned, has said that these are the things that should be done. For example, like Mona mentioned, like I mentioned, that improper constitution of the IC, training of the ICLC is not being done. These are the lapses. Now, to overcome these lapses, as you rightly said, some directions have been issued by the judges. What are these directions? These directions have been given to the government. These directions have been given to the body of professionals, statutory body professionals. These directions have been given to other bodies as well. I'll talk about them. Now, as far as the government is concerned, it's a union, state government, union territories, to all. Now, the judges say in this case, honorable judges say, that you should do a time-bound exercise. This is a direction to the state government, to the union, that you should do a time-bound exercise to verify whether all the ministries under you, departments under you, have constituted IC or not. And what is the composition of these ICs? This is the time-bound exercise that they're supposed to carry out. In addition to this, they also say that all the necessary information that is required, for example, constitution of the IC, composition of the IC, email IDs, contact numbers, it should all be present on the website of the government, on the website of these concerned authorities. This all is a time-bound exercise. Now, if you really go to the website of the Supreme Court and look at this particular case, almost 120 notices have been issued. Now, notices have been issued to whom? Again, union government, state government, various ministries. And the notices say, please come back to us and tell us what is the status. Have you made an IC? Have you constituted an LC? If not, then why? What is the reason? If you have constituted, is it nicely done? Is the composition right? Have you given them training and things like those? So that is what is the time-bound exercise for the government to come back to the judiciary. Let me pause here so that Mona can also fill in.
Yeah, and the similar exercises have been given to the statutory body at apex and state level as well. In all the universities, colleges, training centers, education centers, they are also need to follow all these directions that have been issued here. And immediate effect and effective steps are to be taken under this. And authorities, management, employees, they should have the regular orientation programs, workshops, seminars, they need to upskill the members of IC, educate them how to handle the cases when it comes to them.
Mona, I think here the focus of Supreme Court is on the duties and responsibilities of the employer. Suppose if you have more than 10 employees in your organization, then you need to constitute the ICC. Even if you have the less than 10 employees, then you can have at least the POSH policy. And so how do you see what is the rules, what is the role and responsibilities of the employer in the prevention of sexual harassment at the workplace?
So it is the prime responsibility of any employer, whether it is government organization or whether it is a private organization, to have this POSH compliance in their organization. What it means is that they have to have a proper POSH policy made up. It is distributed among all the employees. And if there are more than 10 employees in an organization, then the internal committee should be there who handle all these cases. And this internal committee needs to be properly educated how to handle those cases, because confidentiality is the prime aspect here. Also, if the number of employees are less than 10, then they need to go to the local committee, which is been authorized by the district officer there in the local area. So and educating the employees also, telling them what all it consists, what all sexual harassment consists. People may be thinking that only the sexual act is the sexual harassment. It is not. Even the colored remarks, even the singing the song, the inconvenient song in front of somebody, making them uncomfortable, also constitutes sexual harassment. So everybody needs to be properly educated what all it involves, and where to address your issues when you come across. So it is not what is said, it is how it is being perceived by the person whom somebody has said something which is uncomfortable to them. So it is employer's duty to educate all the employees, make the proper IC committee meeting, IC in place, and educate them how to handle the sexual harassment cases when they come across. Yeah.
Then, if you look at the Supreme Court's order, so the court is also trying to stress on a point that most of the women don't file the complaint. Sometimes they're not sure about the redressal process, maybe not sure about how much time it is going to take, maybe not sure about how to file the complaint. So generally, they prefer to quit the organization and let's join somewhere else. My question is, if you can help us to know that how to file the complaint, maybe in the case of online and also in offline. And second, how the employers can finish their inquiry process in a time-bound manner.
First, how do you file a complaint? Now, typically, like we've been discussing, and you said right at the beginning, if you have 10 or more employees, it's expected that the workplace would have an internal committee or an IC. The first point of contact for a person who's aggrieved would be to approach the IC. Now, it is possible that you do not know who are the IC members in your location. One of the duties of the employer, what Mona just mentioned, is also to display by posters in your organization. And this is included in Section 19 of the Act. Display by posters in your organization who are your IC members, who are the LC members, so that at any point, if you are aggrieved, you know where to make a complaint. First point again, where do you make a complaint? You make a complaint to the internal committee or the IC. These are the specialized group of people who carry out an investigation in the matter of a sexual harassment. It is not HR, it is not admin, it is not leadership or anyone. Only and only IC has the jurisdiction and the prerogative to carry out an investigation. So to answer the first part, it has to be the IC. If you're not aware who the IC is, find out from your HR. Find out from your employer, have you constituted an IC or not? If they haven't, because let's say if they are less than 10, then you have the option of going to a local committee or the LC. which is something which is constituted by the district officer in each district. For example, in the district of Gurugram, I am a member of the local committee or the LC. So in a situation where you have cases coming from an informal sector where we do not have 10 people, such cases are handled by us. So this is the first part, trying to answer your question. Where do you complain? You complain to either the LC or the IC, depending on whether you have an IC in your organization or not. How do you make sure that you complete the investigation in a time-bound manner? Great question, Ramesh. Honestly, I think education is very important. The IC needs to be educated on how to do an investigation. There is ample time of 90 days, which is provided under the law to finish an investigation. In fact, if I were to give you a complete picture, the law says that once you receive a complaint, in a way your timer starts. Within 90 days, you have to finish an investigation, and then you get an additional 10 days to write a report, which means within 100 days, you should be able to complete the investigation, write a report, and give the copy of the report to the employer, which is, in my mind, a reasonable time for anyone to do an investigation. The issue comes mostly when people are unsure how to respond, how to react. For example, I've seen so many cases where, let's say, a complaint has come from someone. Now the IC members are not educated enough. They will sit on that complaint for 10 days because they're like, what do we do now? How do we respond? Should we say acknowledged? So imagine there is someone who sent a complaint who's expecting that she will get an immediate response. It's been 10 days and she's still waiting, wondering, did this even reach the right people? Why are they not responding? And the right people are not responding because they're thinking, okay, how do we draft an answer? What should we tell her? The uncertainty. And again, I go back to where we started. The law in this case is very clear. You have to educate, you have to empower your IC members. This is something exactly what the Supreme Court judgment also said. Impart education to them, let them know how to handle an investigation and inquiry. Not giving too long an answer, so I'll pause here. Let me know if you have a follow-up question.
Yeah, so Mona, we talked about some time-bound exercise. So, in your opinion, what are the reasons to get delayed this process of inquiry?
If I see people are not educated enough or they are not being trained how to handle an inquiry, the first point, if within 24 hours or 48 hours maximum, they need to respond to the complaint which has come. They need to acknowledge it and initiate the meeting with the complainant, first meeting. And then the same complaint needs to be forwarded to the respondent and initiate an immediate meeting. So within 1 week itself, these two meetings needs to happen. And then the process of having a witness, finding out the witness if there are, and including them into the inquiry and taking all these steps, what happened, how it happened. So all these things needs to be taken care of within first 10 days rather than sitting on it, how to respond to it, as the practicality comes, as Jayant was saying. Yeah.
Yeah. So, Mona, how the employers can sensitize their employees, how they can create awareness, how they can educate their employees about the sexual harassment at the workplace so that they can file the complaint if anyone is a victim of the sexual harassment at the workplace.
Yes, so there are trainers now, like I'm one of the trainers. So we go into the organizations, we sensitize the employees, we tell them what all it includes, what are the different definitions, how to file a complaint, in how much time, immediately probably the person is not ready when the incident has happened. So how much time do they have before they can file the complaint, so that they gain the strength, they are ready to go ahead with the inquiries, which immediately they may not be ready. So all these things are being told to the employees, how to what are the different terms, how to file the complaint, what to do after the complaint, the confidentiality is maintained in the whole process. So these are the things which are taught by the trainers, external trainers, which come in handy in all these things.
Jayant, I think we have covered all the important points of the Supreme Court's judgment. So anything important which is not discussed, would you like to share?
Probably I'll begin by saying that, honestly, this law is very well drafted, though there are things which are a little desirable from my own personal standpoint. First, I would say I wish it was a gender neutral law. Right now, as you know, Ramesh, this law is only for the protection of women at the workplace. The way things are today at the workplaces, it would have been much better had this law been made gender neutral. Secondly, probably the procedural part of the law could also have been made slightly better. Right now, when you have to do an investigation, it only says follow the principles of national justice. A little more nuances would have helped. Now, Mona said that, when we do a training, we talk about definitions of employee, workplace, and things like those. If these were more clarified, I think a lot of help would have been given, and there would be lesser case laws, because a lot of people are at this point litigating on who's an employer. That's also a question. Different courts are taking different views. So probably all these would be helpful. But then again, probably I'll say it's not all bad. The fact that, a POSH law provides you uncomplicated, economical route, if I may, where you can just simply go inside your own organization and file a complaint. You don't have to go to a lawyer. You don't have to go to police station. All of this can be handled internally. I think that's a great piece of legislation. So if rightly implemented, I think we'll do a great job.
And Mona, what are your concluding remarks?
Yes, so I would like to add here some of the companies who are following gender neutrality. They are including everyone in the POSH Act and the redressal, even if it means that they cannot submit the report to the authorities. They are addressing it within their organization. So that's a good start, I would say. And yes, and it's a good act. I was also working in corporate at some point of time. At that time, the act was not in place. So yes, I did face certain issues, and those were not addressed. And that today's generation has this leverage, and the only thing is that people needs to become more aware of certain people that I have spoken to. They are still not gearing up to this. And even if I tell them that, there is a penalty of 50,000 or all these things, they come and, oh, we will handle it at our end. They are so sure of handling those rather than implementing this POSH Act in their organization. So there is a need to, like, filing your returns is compulsory. Also needs to get into this level where it is so compulsory that without it you cannot survive. Your license is not even issued, not POSH compliant.
So, thank you, Jayant and Mona, for joining the conversation and sharing your wonderful thoughts on this. Thank you so much.
Ramesh, it was a pleasure. Thank you, Mona, for being such a great panelist. Thank you.